my initial comments received such a warm reception. I guess, let me ask, are folks, do we want to pursue representation now, or would you rather shift to other parts? We've got other parts of chapter 111 that are not representation in front of us today that we can spend our time on and try and capture some ground there. Or would you rather see if we can work our way through representation?
I moved to table representation right now and moved other things for this meeting.
Without any formal process or vote, anybody opposed to that?
I think Gretchen agrees.
All right. I mean, I do. I'm concerned that we can spend all the rest of our time on representation and still not have something that we would be ready to present. So then let's just do that. It's time to. It's a Shackleton moment. We're going to toss the single malt. We're going to leave it behind in Ocean Camp. Rick, you'll know what that is. And so let's do something else here. I'll just say, let's look quickly at sections 1 and 2 of the working draft that Lorianne sent out. Of course, section 1 is just technical. Number 2, are we good to go with section 2? We've worked on that.
We the group agreed on the language in section 2 previously.
Yep.
So unless,
want to make sure. And that really stands alone from representation, and I think is a very helpful would be a very helpful amendment to the probate code. Does anybody have any issues with that? Okay, so let's say section 2 is in. Then if we bypass representation, that takes us to section 7 of your draft, Lorianne?
yes.
Okay. Everybody okay with going to section 7? Let's take a look at that. Lorianne, do you want to walk us through that?
Yeah, and I think it would be helpful if folks have the, I put together the section cheat sheet,
Yeah.
and it kind of groups everything based on topic area instead of numbered by, chronologically by section number.
Sure.
So there are several sections dealing with the notice provisions. And my biggest question about these, and just to clarify, because I know there were some questions about this, the big capital letters in the lead line, like the CCC, DDD, that's provided just to give a quick cross-reference between the draft and the language that was provided to me by the group back in, is it February now? Something like that. So my question on this language, and my understanding is that this is really trying to mirror Chapter 130, is whether we can just combine these with ORS 111-215, or if not, if there's a reason that some of these provisions differ from 215, because I don't know what really went into the considerations behind them, and I haven't really tweaked these all that much from the language that was provided. So.
Okay. Well, chapter 111-215 is on page 16 of that working draft. So I wasn't involved in that conversation about the notice provisions in sections 7 through 10. If somebody was in that group.
I think it was Heather Brooks, maybe Matt Whitman. No?
I think so. That's my memory.
That's right. And Heather said she may not be able to be here today due to things from related to the fire.
I was on sabbatical when that went through, but it all makes perfect sense. And Lorianne, I think that your question of whether or not it can be combined is absolutely. I mean, yes, it's all of one. It's all of one whole.
Yeah.
So maybe if the group is okay with combining it, maybe we can table the notice sections for today, and I will go through and work on combining those with chapter 250 or the 111, 215, and then the next group meeting, we can go through those changes, or I can circulate a draft that people can take a look at, just in the interest of time.
Sure.
Does that work for folks?
Yeah.
Okay.
I guess, yeah, I think so. If we table that, we may be done by 10:30, who knows? But just a question, I guess, the language no, we'll come back to that. I do have questions about this language. I don't know what the nature of the person's interest in the estate means necessarily. But okay, so let's table that, but be prepared to come back to that before we leave off today. So that would take us then, excuse me, through do we go to 10A of your draft, Lorianne, or?
I think let's talk about definitions, because that's the one that I actually had the most questions on.
So that's section 11.
Give me 1 second so I can make sure I can understand my notes.
We're already getting into conforming amendments, so.
Okay, so my big question with the definitions,
Sandy, while Lorianne is looking, would you go ahead and resend the e-wills?
Sure. The information? Yeah, I'll do that right now.
Yeah, the copy of the act. We may have time even to get into that today if we're putting some of these things on, if we're tabling some of these things.
Okay.
Okay, back in April meeting, we talked about potentially defining probate and probate proceeding. So we're on page 11 of the working draft. And I don't know if y'all remember this conversation. It took up a bit of time. And the group pretty much, we punted on the question and said that we'd come back to it. So now's that time. I'm concerned about defining probate proceeding though, because we really should go through every instance of that term in the code to ensure that whatever definition we give it isn't going to mess up some other section. And specifically with the changes that we made with section 2, which is the exemption from the ORCP and the Oregon Evidence Code, we're saying that that applies to probate proceedings, but then we've said that in particular, some of the statutes that are in ORS chapter 115 aren't part of that, but those statutes do use the term probate proceedings. So if we define probate proceeding to be a proceeding under chapters 111, 112, 113, 114, that's going to pull those exceptions back into the exception from the ORCP, if that makes sense. So those are the applying to the court for summary determination of claims. So I think that this could have unintended consequences that
or at least require some more careful drafting, extensive drafting from you.
Yeah.
In those other sections.
Yes.
Let me ask again in light of that, what do folks feel? I guess I would ask: is anyone aware of a situation in which the lack of a definition of probate or probate proceeding has been problematic?
Brooks here. I have not.
I have.
Sorry, go ahead, Judge.
Oh, I was just saying I can't recall any that I've had.
No.
And so this is Whitman. I've seen some people get confused about whether or not a matter that is required by local rule or uniform rule to be filed in the probate department is in fact a probate matter. So I've heard people refer to trust matters that are definitively filed under Chapter 130 as probate matters. And so that can, there's a lot of synergy and interlocking between the statutory schemes, but a trust proceeding isn't a probate proceeding.
Similarly,
is that a function of the trial court rules, though? I'm not sure that a definition in chapter 111 would clarify that if a local trial court assigns trust cases or trust proceedings to their probate department.
I think that's.
Well, but Lane,
Go ahead.
but it would solve that problem, Lane, because the trial courts are free to say, you must file this kind of action in the probate department, but it doesn't make it a probate proceeding.
Right.
So we don't end up with people trying to apply chapter 111 in a trust proceeding governed by 130.
I'd also think that, when we say that a proceeding is under chapters 111 through 117, I mean, not all of those chapters authorize the filing of an original proceeding. And so to that extent, if we're talking about what we've spent so much time on in determining a contested probate matter issue proceeding dispute, you could, for example, say a proceeding filed under a chapter that authorizes an original filing.
I'm sorry, I lost you on the tail end of that. What was that again?
Chapter 113 is actually the chapter that authorizes the filing of a probate, intestate or testate.
Right.
And 117, as I recall, allows you to open estates of absentees, for example.
Right.
But there are no, unless I'm mistaking myself, chapter 115 doesn't permit original filings. You don't file something under chapter 115. It tells you how to determine claims and such. 114 permits the latter sections of chapter 114 permit small estates, but, and maybe there's such a thing as a petition to forfeit a parent's share under chapter 112. Maybe that has original jurisdiction, but maybe it doesn't. But what I'm getting at is, you can just say something filed under one of the chapters that permits an original filing, as opposed to just an issue that's going to be determined under the rules set forth in other chapters. Whew.
Yeah, I'm not sure that's really clear. Who and who? I thought somebody reacted to that.
Wasn't the kind of impetus for trying to define probate proceeding because Section 2 of our draft
Right.
talks about that the rules of civil procedure and rules of evidence code do not apply to probate proceedings. And then the exception, though, well, let's see. We say ORCP 12 applies to any probate proceeding, and then a list of ORCP sections apply to a contested issue in a probate proceeding. If we're concerned about defining probate proceeding because it is used elsewhere in the code and we don't want to check
Right.
the implications there, should we just change Section 2 to say, rather than a probate proceeding, do not apply to a proceeding under chapters 111 through 116?
Is that what we mean? Is it wholesale? Or another thing I was thinking was, if we wanted to say use probate proceeding, but also cabin the concept for Section 2, we could, I think, Lorianne, could we say as used in this section probate proceeding means? Or would that be frowned on?
I mean, I think we could if that's the goal is just
Well,
to,
yeah, I'm not saying that we want to, but we could, yeah.
My question then is, it still goes back to, if we say that probate proceeding means, a proceeding filed under chapters 111 through 116, 117.
117.
What that does to those one-off sections, like what's in 115 for summary determination of claims, if we need to exempt that, or if that's clear that those aren't intended to be considered filed under. I don't know how those work, so I don't know. I've never seen one in practice, so I'm not quite sure. The practitioners would probably have a better understanding of how that would be applied.
A quick response to Lane's suggestion about defining it for the purpose of this section. Taking a look at Lorianne's outstanding questions sheet, one of the other statutes that she cited to was ORS 3.408. I had just flipped to that one to take a look. That's the statute related to setting up the family law department of the courts, and it describes that the presiding judge may assign to a family court department the following matters, and one of them listed is probate proceedings under ORS chapters 111, 112, 113, 114, 115, 116, and 117. So I'm not, even if we said here for the purpose of this section and defined it to say that, I think when you read that other statute, it would be natural to import that, because it's saying a probate proceeding under those chapters, and when you turn to those chapters, that's how we're defining it there, and it sounds like it would incorporate. So I'm not sure if that's going to get us past having to review each of these statutes that Lorianne listed.
What if we instead defined it in the negative? I know we don't actually like to do this in LC, but we could say that for the purposes of these chapters, that probate proceeding does not include, and you would include, exclude proceedings filed under like ORS chapter 125 and ORS chapter 130. But then are there any other chapters any other cases that are filed in probate court that we want to make very clear are not probate proceedings?
Civil commitments and name changes.
David, is this all a function just of how courts have organized these for administration? I mean, through the probate department? Is that what
name change statutory, and I haven't looked at civil commitments recently, but I believe, I can't swear to that part.
So we've got civil commitments, name change, I'll double check that. Name changes, protective proceedings, and trust matters.
Right.
Are there any others that y'all can think of?
That we would say are not probate proceedings?
Yeah.
Well, by either court rule or custom, the Chapter 125 protective proceedings happen generally on the probate docket. I'm not sure that's the same as the mandate to put trust matters on the probate docket, but I mean, that's where those things always end up in practice, and I'm not entirely sure why.
But if we exclude Chapter 125 proceedings from probate proceedings in Chapter 111, then we're saying that the Chapter 111, the probate proceeding rules don't apply to Chapter 125 proceedings.
Yeah, and that would solve that issue, assuming it is an issue, easily.
What about the abuse? So elder abuse cases, are those filed in civil court? Or those aren't filed in probate, are they?
Yeah, damages and injunctive actions are filed in the regular civil courts. The EAPA restraining orders, I think they may happen on the same docket as the family abuse restraining orders, but they're designed to be self-represented matters, so I'm not really involved in those.
I think Brooks is right that they're generally with the restraining order matters.
Okay.
So
what
what are you proposing then to do with this? Are we taking it out of subsection 125 and putting it into section 2? And how would you propose to address it in section 2 then?
So this is Lorianne, and I think that it would make sense to pull that definition out of 111.005 and drop that into section 2 that just says, for the purposes of this section, probate proceeding does not include, and then list out those. We've got civil commitments, which I'll double check to make sure that those are filed in probate court, name changes, protective proceedings, and trust matters. So
what about chapter 126, any of the property for minors or uniform transfers to minors?
I would exempt that too.
okay.
I'm not quite following though why we're thinking that this would if we defined probate proceeding, that it would unintentionally pull into the definition things that we're elsewhere excluding, because this is still within discussion of section 2, right? And the first part of section 2 is to say that the rules do not apply to probate proceedings. So that would mean, you know, everything, the initial definition would be every probate proceeding, which would be any proceeding under any of these chapters, the ORCP and evidence code would not apply. There's in that paragraph a list of exceptions, and then paragraph 2, section 2, paragraph 2 lists further exceptions, and the issues surrounding the summary determination proceeding are not that those are not defined as a probate proceeding, they're defined to not be a contested issue. So don't we, I feel like the current definitions, and if we defined probate proceeding, or if we don't and just use, you know, a proceeding under chapters 111 through 117, I'm not sure that it would unintentionally pull in something that we're excluding elsewhere, because I think we've successfully excluded those.
So what is a maxim is specific over general in legislative interpretation. So is that going to protect those then? Is it specific enough?
I think so.
Help me, so is what specific enough then? Make sure we're.
The exceptions, you know, like in summary determination, have we clarified that it would not be part of a protective proceeding? Is it clear enough that it's a specific exemption? It would be considered a specific exemption to a general definition.
And that we don't mean to override that exemption by adding, by defining the chapter within probate proceeding.
Well, I don't even think that's the question. It would be a probate proceeding, but it would not be a contested issue in a probate proceeding, because we've defined it to not be a contested issue unless the court makes it a contested issue. So we have two different defined terms, and it's part of.
True. So, Matt, are you proposing then that we can, instead of the exclusion by definition, I'm sorry, definition by exclusion, that we can use the definition of a proceeding filed under 111 through 117, and rely on the exception to contested case or contested proceeding to protect the overreach of this?
As to the concerns about whether it would confuse the question of whether the ORCP and evidence code would apply to,
right,
like, for example, the summary determination proceeding, I think that we were successful in section 2 to
yep,
lay out when that does and when it doesn't.
Lorianne, what do you think about that?
I think,
Oh, go ahead. I'm sorry.
I think that section 2, paragraph 1, at the end of it could say, do not apply to probate proceedings if we are defining probate proceedings, or could say, do not apply to a proceeding under chapter 111 through 117.
Yeah.
And then the following creates exceptions to that, which I think would still be valid exceptions, although we'd have to address how the following paragraph references probate proceeding, right, as well. So for the purpose of section 2, I think it would be okay as is. It doesn't answer Lorianne's other question, which is, if we define probate proceeding here, it's the phrase probate proceeding is used throughout the ORS, and there's a number of other instances that we might have to, if we're going to define it, that we would need to look and see what implications it has. And so we might want to not define probate proceeding, and instead of using that phrase in
right,
section 2, we might want to say something like a proceeding under chapter 111 to
right,
117.
What do you think of that, Lorianne? Just take out probate proceeding. What's your preference? Either to define it and make it subject to limitation to that section only, or just take out probate proceeding and use the reference to the statutes the way chapter 111 begins with anyway?
Yeah, I'm fine with doing the latter. So it would just be, does not apply to a proceeding under chapters 111, da 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 da.
Yeah.
But my question, and this is for maybe Matt Schrumpf and Brooks and Matt Whitman, would be if that is sufficient to clarify that those summary determination matters that are filed under a different case number, if those are not included. So the reason for my concern is right now the status quo is that the ORCP and the Oregon Evidence Code do apply to probate, to everything under chapters 111 through whatever. But we are creating an exception, and we're saying that the ORCP does not apply except in these instances. And there was a lot, we spent, a couple days talking about how to deal with these summary determination cases, and because you do want ORCP to apply to them. So we have excluded them from contested, what is it? We ended up going with a contested issue in a probate proceeding, but that doesn't necessarily mean that we've excluded them from a probate proceeding. If we're clarifying that a probate proceeding under, or a proceeding under chapters. So I guess the question is, those summary determination cases that are filed under a separate case number, are those filed under chapter 115, or are those filed under something else? Something else? Matt,
I would say they're filed
Gotcha.
under chapter 115. I'm not sure the assignment of a case number has any bearing on whether it, on whether it's filed under the authority of that particular statute.
And this is Brooks. This is Brooks. If a creditor seeks summary determination after denial, that happens within the probate.
Right.
It's only when the PR says no, go sue me in circuit court, that we get a brand new civil action, which is completely unconnected from the
Right.
probate proceeding.
And in that case, the ORCP would apply because that's not a probate proceeding.
Right.
That's right.
It's an action against the estate.
Yeah, that's a civil action
Well,
just
that-
like any other.
That's Lorianne's point, though, right? So I think I follow your concern now, and I think I would want to take a little time myself to look at Section 2 again and figure that out. And I'm wondering if maybe the way around it is just to add that in as another specific exception. That an action filed under 115.145, is it 1B or something like that, would be, maybe what I'm thinking is maybe the beginning of Section 2, Paragraph 1, which begins with except as otherwise provided in, and then we have a list of other statutes, and we could add in a reference to say something about, you know, action filed under, or a separate action
Yeah.
filed under 115.145.1b. So that would be included as one of the except as, well, it wouldn't exactly fit as except as otherwise provided, but we could figure out some other language. So it would say, you know, and except as to an action filed under 115.145.1b, the ORCP and rules of evidence do not apply. Or maybe we list it in paragraph 2 as another lettered subparagraph.
Yeah, that's interesting. I guess but there are other, I mean, apart from that, there are, I mean, you could have a quiet title action filed against an estate, for instance, by somebody who wants to determine an issue of interest in real property. And I assume that quiet title action would not be deemed a probate proceeding just because an estate is a party to the action. So
Well,
really, is that
well,
what a class of cases where an estate is a named party, but it's not? Yeah.
Well, but Lane, in that circumstance that you pointed out, the probate court is expressly authorized to determine claims of title when the PR is one of the claimants.
Yeah, I just made that up. But it seems like there are other.
But I don't think that's a necessary. Is it?
Exclusive? Yeah.
No, I agree. If I think I co-own that Blackacre with the decedent, I can just file a quiet title against the PR in circuit court if I want.
And that's not a probate proceeding.
Right. What if I'm the neighbor and I think I acquired title by adverse possession?
Right. So is there somehow that we can express it really more generally? Well, the Section 2 doesn't apply when an estate is a party to.
What about just the administration of decedent's estates under chapters blah? I mean, would that be sufficient to exclude those separate one-off cases that are filed under different case numbers?
No.
I would think that can get to the quiet title example. I'm not sure if it gets, if that would distinguish litigation over a claim against the estate that has been disputed and is now being resolved in a separate action. That to me does seem like part of the administration of the estate.
Yeah, I agree. That might require a separate call out because that's within that series of statutes, or the authority anyway, to bring that. But then we may still want to have a more general, and Lorianne, I think your language was getting there, really addressing this to proceedings in the administration of the decedent's estate under those chapters.
So what if we do this? What if we stick with defining the term probate proceeding for the purpose of section 2 to be a proceeding under chapters 111 to 117, and then have a subparagraph that says, notwithstanding paragraph A, probate proceeding does not include a separate action for summary determination of a creditor's claim under 115.145B.
Yep. Are there any other proceedings within that series of chapters that we would need to specifically address? Nothing comes to mind.
I think that we, and Brooks and the Mats might correct me on this, but I think that we talked about this when we were when we had our separate group meeting on section 2, when we were trying to figure out how specific to get with the exceptions. So if that's the case, if we've already looked into, combed the code for those, and this is the only one. I know there's for the small estates, you also have a summary determination of claims process, but I don't think that one, is that one a separate case that can be filed, or is that just within the?
Yeah, that's solely within the small estate case number.
So is it your understanding that 115.145B is the only place in the probate code, that chapters 111 to 117, that might be an issue with defining the definition of probate proceeding?
I would agree, but I will point out that if someone believes they have a claim against a decedent which is covered by liability insurance,
right,
they can proceed directly to file in circuit court without going through the claims proceeding, but that would result in the same result as a denied claim that goes to circuit court. So I don't think that's an issue. Just pointing it out for the group.
All right.
Okay.
So let's say we're not going to define probate or probate proceeding in section 11 of this draft. We'll take it out of 005. We'll put it in section 2. And Lorianne, do you feel like you have enough direction from this to prepare language for us to review next time in section 2?
Yeah. And I do. Does anybody else have any lingering comments on that issue?
Yeah, I have one to float. Give me 1 second here. I'm wondering, so 114.275 gives a personal representative or any interested person the ability to apply to the court for authority, approval, or instructions on any matter concerning the administration, settlement, or distribution of the estate. That's very broad, and clearly that's within, that would be something filed within 114, so would seem to me to be a probate proceeding. My question for everyone's discussion is, Chapter 28 has authority for a declaratory judgment action related to an estate as well. And I've always thought that, at least conceptually, there's kind of some relation between these, so that maybe in theory you could file, and I think I've seen petitions for declaratory judgment or that are filed within the probate proceeding because, you know, it's relevant to the administration of the estate, and I think ostensibly are filed under 114.275, but the statutory authority for a declaratory judgment on an estate, or, well, on an estate, would arise under Chapter 28. So I don't know if maybe we want to make clear that if you're filing a declaratory judgment action? Is it outside? Is it not a probate proceeding, and so ORCPs and rules of evidence would apply?
So this is Lorianne, and I think that's a really good point. And I think that if we do not specifically accept the declaratory judgment actions, that we may run into some due process issues and some we may run afoul of the Declaratory Judgment Act if we're saying that the ORCP and the rules of evidence don't apply to those cases.
Right.
But that's a consideration that I haven't looked into, but it is something that I definitely flagged when I was drafting this. So,
and I don't get the sense that when we were, or our subgroup, I wasn't involved, but I don't get the sense that Section 2 was meant to say that the ORCP and rule of evidence wouldn't apply to a declaratory judgment action. I raise it just because I think there's some gray area around how those can be filed, and I've seen them filed within a probate. So I think it would warrant some clarification, and I think the clarification probably is ORCP and rules of evidence apply to an action seeking declaratory judgment.
This is Whitman. That was certainly our intention. I'm looking at, I've always viewed the grant of authority to the probate court to make declaratory judgments and the essentially congruent provisions of ORS Chapter 28040, which I'll point out is a statute that was last amended in 1961 as being totally congruent. In other words, I don't think that you can, to ascertain, direct. Why does 28040 still exist?
Well, because DEC actions can exist beyond probates.
Yeah.
So
And I think 111.005 does give the probate court the power to make a DEC action regarding probate res or probate rights.
No, I mean, what does 28040 do that isn't contained in the more specific statutes in the probate code and the trust code? I mean, I'm looking at it right now. We have specific provisions relating to every single thing that 28040 provides.
That's a,
Fair point. I just went back and looked. I think it got missed when the probate code was adopted.
All right, so we should repeal 28040. Great, done and done.
Obvious.
yeah, is that a direction to me to add that as a repealed section?
Sure.
One point I do want to make, going back to Matt Schrump's comment about DEC actions and the application of Section 2 to those, is does the exception, the subsection 4A to Section 2, the big A, we do say that a DEC action is a contested proceeding in a probate, or contested issue in a probate proceeding. Is that sufficient to cover all of those, do you think?
Well, I had noticed that as well, and here's my messy stream of thought. So, yes, in the sense that a declaratory judgment proceeding, that the only way I can interpret that would be that would include any action seeking declaratory judgment. But then we have to go back up and figure out what that means. That means it's a contested issue, and a contested issue means that the rule of evidence would apply. And it means that the list that, let me point to you. I'm reading section 2, paragraph 2C. Oregon Evidence Code applies to a contested issue in a probate proceeding. Section 2, paragraph 2B, that laundry list of ORCPs applies to a contested issue in a probate proceeding, so it would apply to a DEC action. The other ORCPs would not, and I don't know whether that creates an issue or not.
And I think that was Brooks and Matt Whitman. You two were involved in the overall review of the ORCP and coming up with this list, right?
We did. We spent a lot of time on it.
So do you have any comments to Matt Schrump's question?
I don't understand the question. Maybe I just didn't follow.
Is there anything in the ORCPs that are not listed in that laundry list that should apply to a DEC action?
No, I don't think so. What we did was we went through and took out things there's no, in our view, no possible way they can apply, such as provisional process prior to filing of an action, or temporary restraining orders, preliminary injunctions, jury trial rules, verdict form rules. And, we did pretty carefully go through each one and try to spitball, is there ever going to be a time that this is going to matter in these proceedings we're talking about here? And Matt and I were confident, he'll tell me if he still is, I am, that we got that one right. So I'm comfortable we're fine.
Okay.
We spent hours on that.
Let's go with that.
My only concern, and I think this could use some, maybe if people can take a look at it and come back to the next meeting, would be excluding the application of ORCP 4. And that's jurisdiction. That has some jurisdiction components, because this is one of my outstanding questions, actually has to do with jurisdiction and some changes that the group made in prior sessions. So I think that would be the only one that I've flagged as being concerning.
Okay, let's try to summarize where we, oh, go ahead.
Sorry, I have a different thought that pops into my head about a particular ORCP. If you were filing a regular DEC action, you would be serving pursuant to ORCP 7. Are we confident that if you are filing we'll call it a petition for declaratory judgment within a probate proceeding, are we confident that whatever service is going to be required under 111 at Sequium is sufficient?
Can I?
Go ahead, Matt, and then I'll chime in as well.
Okay, so ORS Chapter 28 and the declaratory judgment law generally requires that all parties be made, that all interested parties be brought before the court and be made parties. And we know in Chapter 130 proceedings, at least for the past 14 years, that we've had no problem making people who are interested parties in trust proceedings parties to DEC actions through the kind of mailed notice, not ORCP 7 style personal service that is otherwise required in freestanding DEC actions. So to answer your question, Matt, I think that, yeah, we can have DEC actions that take place under an existing probate case number, and except where any specific provision, will contests are routinely commenced through mailed service of process. And we've never had a big problem with that not taking place through our V7 process.
And this is Brooks. I'll chime in, and I agree with Matt. My view of it is the due process rights implicated in a probate are always a limited set of the rights you've got. If I sue you in circuit court, I may get an infinitely large money judgment, but in the probate court, what's at stake or at issue for you is only your interest in the asset or assets we're fighting over. And I also don't have a problem with the mailed notice and time to object rather than forcing every deck action contestant to personally serve a chapter or a Rule 7 summons on everybody. We see this a lot when someone thinks they were an adopted kid, but it's lost to the mists of time. And in that case, to make them, personally serve 7, 8, 9, 10 heirs or devisees is an expense that I don't know is worth it. So I don't have a concern about that for the same reasons Matt expressed.
And looking at section 111.215 sub 1, we already say notice has to be given to each person interested in the subject of the hearing. That would seem to be coextensive with the requirements of the deck action. So Matt, is that okay?
Yeah. Well, in Lane, that's correct. There's a Supreme Court case that says that, Eddie against Eddie. So yeah.
All right.
I wanted to raise it only because not because I had a personal opinion on it, but thought that it was worth confirmation.
Well, let's go back to section 2 then and see if we can summarize where we are so we can make sure Lorianne has her direction. Lorianne, would you tell us what you think you've heard?
Okay, so what I've heard is we want to repeal 28040 because that's already, everything that's in that section is dealt with in the probate code or the trust code. And then go in and I will add a definition of probate proceeding to be a proceeding filed under chapters 111 to 117, and then create an exception to that saying a probate proceeding does not include a separate action for summary determination filed under 115.145B or a declaratory judgment action under ORS chapter 28. Does that make sense if we've already repealed 28040? Is that good?
Yeah,
Everybody's okay with
it? Do we need that if we repeal 28040?
I was mostly serious about that. I think we've now got multiple statutes saying the exact same thing, and under legislative interpretation, that means we have to figure out what they mean that is not exactly the same, because we know the legislature never passes two statutes to say the same thing. That is a constructive fiction under which we always labor.
I do regret losing Seneca Trust from the ORS. I'm not sure if there's any other statute that uses Seneca Trust, but I think that makes sense. So that if we repeal 28040, then I think we don't need to exempt deck actions specifically from the scope of section 2. That is, deck actions under chapter 28. Does that all be subsumed within the probate code, right?
But we would.
I would agree.
The reference in section 2, paragraph 4AA, that describes that a declaratory judgment proceeding. Maybe we rephrased that a little bit, but we would want to keep something that says that declaratory relief is a contested issue.
A proceeding for declaratory relief or something like that.
All right.
Okay, let's try that.
All right. Can we move on?
Yes.
Okay. So there's one more definition in 111.005 that I would like to touch base with y'all on, and this is not something that the group has brought up at all, but it is something that I think I want to confirm that you guys are all in agreement with the recent Supreme Court case, Price v. Lickar. So the definition of interested person. My reading of this has always been that the definition of interested person includes heirs, devotees, children, spouses, creditors, and any others having a property right or claim against the estate of a decedent that may be affected by the proceeding. In Price, the Oregon Supreme Court said that they declined to apply the rule of the last antecedent and applied that clause, others having a property right or claim against the estate of a decedent, to heirs, devotees. So an heir would not be considered an interested person unless the heir has a property right in the estate. A devotee would not be considered an interested person unless they have a property right in the estate. And children, spouses also. Is that the intent? Is that your understanding of the way this should be interpreted? And if so, can we add a comma? Or if it's not, can we fix it?
Go ahead, Matt. It's Matt's case.
It's my case. And so what happened in that case, just so you understand why this is an issue, is the decedent's sisters, who would have been intestate heirs, moved in the probate court, but the decedent died testate. So the decedent's sisters, who would take under intestacy, but who blew the time limit in which to file a will contest, petitioned the court to do really bad things to the personal representative because they thought he was a financial abuser. And the question was, did they retain some status that entitled them to petition to the court, even once it was clear that they would never take, that they had no concrete financial interest or standing? And so the problem with looking at this as a rule of last antecedent question is ultimately that they had status that was lost by operation of law. Were they entitled to notice as people who were heirs? You bet. During that period of time between then and the 4 months before their will contest rights lapsed, did they have all the standing that any other interested person did? Yes. But then things happened that meant that they did not any longer. And so, using an example that Brooks used a minute ago, if there's some sort of declaration that in fact someone who was thought to be an adopted child but was not, and that got adjudicated, that person would no longer have standing. And so I don't think that this subsection, this subsection, is a question of who is an interested person that can be solved by the addition or subtraction of a comma, because it simply changes over time.
And the other quick example, maybe just to make this seem even clearer, if someone gets a specific device of a single piece of personalty, the family piano, and in fact it's been partially distributed to them, why do they have standing to do a thing from that point forward in the probate? And that's what Price holds.
Yep.
So based on what you're saying, though, is that an heir who has standing to do something does have to have a property right or claim against the estate, right?
Yeah, standing changes over time. And that's the thing. We can't look at the institution of the probate and say that's the class of people with standing. They always will. No one else will. It can change depending. And it's so factually varied. I don't see how we legislate and have that capture the million different fact patterns where that concept could occur.
Well, let's think about that initial notice though that goes out. You've got a decedent who dies testate, and certainly we interpret Chapter 113 now to say that even though they died testate and may have left everything to only one of their heirs, the rest of their heirs are still entitled to notice.
But that doesn't, that's based on them being heirs. That's not necessarily based on them being an interested person.
Well, but they're entitled to notice at the beginning of the proceeding because they have a property right in that they have the right at that time to contest the validity of the will that disinherits them.
Okay,
Once they bring it and lose.
That's where I was
Right.
going with my question. Okay.
Yep. Once they bring it and lose, or they let the time lapse so they can't, that property right is extinguished. Their relationship to the estate changes forever.
So backing up, and maybe rewinding to the point where Lori asks the question and it being a good question. Because it is a good question.
Well,
If the nature, if being an interested person is having an if being an interested person is, where did I'm sorry, I lost here, sorry, means having a property right or claim against the estate that may be affected, then what you're saying is anybody's an interested person who has a property right or claim against the estate of a decedent that may be affected, and that may include heirs, devisees, children, spouses, creditors, and anybody else. But ultimately, it's not that status qua that status. You know, it's not naming somebody as an heir. It's not saying, oh, look at you, you would take under intestacy, you're an heir, therefore you're an interested person. Instead, it's look at them and say, do you have, do you have a potential property interest or claim? Am I understanding, Lorianne?
Yeah, so if you look at page 3 of my outstanding questions, I have, it goes page 3 and 4. I have some alternate suggestions for how we can fix this. The simplest is just adding that, basically the comma, so that it actually reads the same, it's doing the same thing that the court says that it does, but employing our normal drafting techniques. I think the first option I have there is actually what Matt was just talking about. So we would rewrite it to say that an interested person means any person having a property right or claim against the estate of a decedent that may be affected by the proceeding. And then going on to say that it includes a decedent's heir, devotee, child, blah, 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 if that person has a property right or claim against the decedent's estate. And it includes the fiduciary representing the interested person.
So I think that, Lorianne, I think that your first example, so first of all, Price was my case. I won that case. It's great to win, but it was the right result. And, sometimes I win cases I shouldn't win. So I think, Lorianne, that your model language on page 3, right underneath, if Price is the correct interpretation of interested person, a more accurate definition may be. I think that's good.
Any other comments on that?
Offhand, I think that's right. My only question is in looking at your sub B there, Lori, in that section, and this is it. If the heir, devotee, or et cetera, has a property right or claim, and again, going back to the beginning of the administration of an estate, would it be more accurate to say that person may have, or are we satisfied that just the ability to file, they may not have any right. There just may not be any way for them to establish any property right or claim against the estate. Would they still fall into this definition?
Well, this is Brooks. Keep in mind, in the situation where we have a will, every intestate heir has a property right in that they have the right to contest the will until they don't.
Okay,
so,
and we're satisfied that is a property right.
Absolutely.
Sure. Chosen action.
I mean,
yeah, okay.
A chosen action is an assignable piece of personal property.
That's good. Yeah, that'll satisfy me. If we have to take out Seneca Trust, we can put chosen action in the comments.
As long as we can describe it as intangible personality rather than intangible personal property.
All right, I think that works then. Are we satisfied with that for Lorianne's question?
So just for clarification, is the one that we're talking about under the current definition of interested person is, and then we're going down to if price is correct?
Yes, and then the first option under that.
Can we, would it, how much, all right, I'll just ask. Can we get a list of the statutes in 111 through 117 where interested person is used?
Yeah, I can make that list and circulate it. I was just looking at it,
Thank-
actually. There are 117
Yeah.
instances
Yeah.
of that term in the code.
Yeah, I was afraid of that.
So I'll take a look at it, and I can put together a list and circulate that this afternoon. So, well, I'll give it to Sandy and he can send it out so you guys can all take a look.
The
Thanks, Gloria.
concept seems appropriate to me, and I think that other places like the information to devisees, heirs, and interested persons statute actually defines better who has to be provided with that information document.
Yeah.
And there may be other places that talk about interested persons that will adequately describe who needs to get notice of something. But in other locations where it's somebody pops up and is trying to ask the court to do something, and there's a response that you really don't have standing to ask for this anymore, that seems appropriate. So I just think we probably need to, I want to look at those and
Fair enough.
make sure that it doesn't have an unintended consequence.
Okay, I lied. There are 230 instances of it when you include interested persons versus interested person.
Oh.
So, and that's not just in the code or in the probate code, that's throughout. So I will take a look at each of those and make a list of the ones that are relevant to this discussion.
Wow, okay.
So could I ask if we all agree that price was rightly decided, does anything need to be changed?
So this is Lorianne, and I would say that if you all agree that price is correctly decided, that we should correct the way that statute is written so that it really resolves the ambiguity that the court had to rule on.
Well, which takes you back to your first option, which is the simple insertion of a comma.
Yeah.
Well, but the court interpreted it. There is no ambiguity.
Well, there is if you read the statute. No, I agree with Lorianne. It may be just housekeeping at this point, but I guess that would be amending the statute to conform to the court's interpretation of it.
Well, but to John's point, if we now have binding Supreme Court interpretation of an existing statute and we absolutely now know what it means,
We don't,
the only reason to amend the statute to catch what the Supreme Court said, and then I'll let Matt talk, is because we think people won't go read the cases. Matt?
Court of Appeals.
Yes, Court of Appeals, right.
Oh, my apologies.
That's
Oh,
what-
sorry.
Yes, we should amend the statute so we don't have to have the Supreme say the Court of Appeals was right.
Right.
Well, they did. They didn't accept review.
They did?
John, that's a nothing. The denial of a petition for review has no precedential effect.
Denial.
Okay.
Sorry, that was on me. I misspoke when I started talking about it.
Okay, so then let's before we leave this, then if all we want to do is affirm the Court of Appeals, do we go with Lorianne's second alternative option, which is just you've added person and a comma? Is that it?
Yeah, it reads awkwardly if you say others.
No.
I just person in the ors means pretty much anybody, an individual or a corporation. It would be that was a personal drafting preference.
I
if
see.
was
Instead of
writing it.
others. Okay. Yeah. Okay.
But I mean, both options there do the same thing. It's just
Yeah.
that the first one is, I think, more specifically calls out the issue that's being resolved by the change in the definition.
That's a good thing.
Yeah, I think unless we're screwing up anything in those 200 and some odd statutes, I think I like you still like your first option better.
Either works for me.
I like it first.
Okay, let's try that for the next draft, Lorianne.
Okay.
Moving on.
Yeah, wait.
Yeah, John.
Hold on.
Okay,
In the
I'm going to
first
step away for a
version,
second, so Lorianne, you're in charge.
in the first version, C eliminates the, if you read C literally, they don't have to have a claim.
Hold on. Wait, what?
No, I don't think that that's
C
what that
trumps,
does.
I think it is. I mean, if an heir is an interested person only if the heir has a property right or claim, but in C, a fiduciary representing an interested person doesn't have to have a claim.
Well, the interested person has to have a
I guess
claim.
well, you're
Yeah, right. That's right, John. The fiduciary for an interested person can bring their right, but that doesn't mean every fiduciary becomes having standing. I don't see how you can read it that way.
Okay. All right.
Okay, so I'm going to go with that, and we can take a look at, I'll send Sandy the list of the instances of interested person in probate code. And if anybody has comments on that, we can address it next time. Does that sound, did we lose Lane?
Only for a minute.
Okay.
I'm back. Yeah, let's do that.
So let's see.
All right, does that take us then to section 15 of, do you want to go there next, Lorianne?
Yeah, that was my next big issue that I spotted, and that has to do with the probate, the jurisdiction, and removing the application of ORCP 4 and ORCP 7. So I think, Lane, you and I had kind of emailed back and forth about this, and you said you were going to delve into this one a little bit more with the group.
Yeah, well, it has to do, what we talked about specifically was your comment on the line, the language in subsection 2. And I know some of you in this group were in the group when we added this language. By accepting a distribution from an estate, the distributee submits personally to the jurisdiction of the courts of the state regarding any matter involving the estate.
And let me just interrupt you for 1 second to make sure everybody's on the same page. We're looking at 111.085 right now.
Section 15 of your working draft.
Yes.
And it's the language that's highlighted in pink on my screen because you've got a comment on it.
So the group's proposal was to delete that last sentence in subsection 2.
Right.
And that's
the small group's proposal.
Yes, and that is what Lane is talking about right now.
Right, and Susan, well, several of you were on the group then. We wanted this language, as I recall, we added it specifically because of concern that if you have for instance, a preliminary distribution, and we need to get property back from a distributee, we want the ability to have jurisdiction over that distributee who has received property or distribution from the estate. Susan, John, help me remember what other circumstances we had in mind with that language, but I know we were very intentional about it.
Heck, I don't remember. I think it was just a parallel to the trust code.
You think so?
I think it was just paralleling the trust code, and it's of limited utility.
Yeah.
Because if you don't get a partial distribution,
right,
then you don't submit yourself to jurisdiction
right.
until the final distribution. At that point, it doesn't really accomplish it.
Right. So what was the small group's inclination as far as removing this?
I think this was Brooks that felt strongly about this.
I recall feeling strongly. I'm now trying to recall why I felt so strongly.
Mostly because you don't think that the probate courts have in rem jurisdiction.
Oh, no, it's because they don't have personal jurisdiction. They have
Okay.
only in rem jurisdiction.
There you go. Yeah.
And that's why ORCP 4 doesn't make sense within the probate code. You know, the court's jurisdiction over me in a probate is limited to my property interest. The court cannot also say, and now you're divorced, for example.
Right.
And that's why ORCP 4 shouldn't be part of our rule.
But I think this was intended as a limited exception to that, or a limited grant of that jurisdiction for the purpose of recovering property of the estate that has been distributed and received by somebody who otherwise the court wouldn't have jurisdiction over.
That's exactly right, because the probate court retains authority over the res, regardless of whose hands it's in, until the court is satisfied that the purpose of administration is concluded. Only then does it lose its jurisdiction over the res. And so that's, yes, we want to be able to claw back when we improvidently grant partial distribution because we didn't know about that creditor or whatever the facts are. I agree.
Yeah. So we leave it in.
Yep.
Okay. Lorianne, what else do you have in that section for us?
Let's see.
Yeah, this is the testamentary trust vacancy.
Yeah, I mean, that's language that was proposed by the group. So if the group is okay with that. No objections? Okay.
Yeah.
So just to confirm that I understand the final agreement on that, we are keeping that language?
Yes.
Okay.
Anybody have any comments on the testamentary trustee vacancy language? I would think that would occur naturally anyway, wouldn't it? But it's fine.
I looked at my
Where
notes
is
on
it?
that one.
Yeah, and we're just rewording language that's already there. So tell me what the difference is.
Well, the concern was, at least in the notes when we were talking about it before, the concern was that if a successor trustee needed to be appointed, that there would have to be a separate action. So the idea was just to avoid the need for a separate action.
Exactly. We don't need to invoke Chapter 130 when we still have a PR and a probate judge in control of the corpus of the trust.
Okay. And the concern
There
was
is.
that the language in little I doesn't already do that. Where it says the probate, the court has the jurisdiction to do that. But if we're just making it clear, that's fine with me.
I think the main change there is that it clarifies that in addition to appointing a successor trustee, you can appoint the initial one if there's a vacancy.
Yeah, okay, that's true. Okay, yeah, I don't think that's not a problem.
All right. So we're cruising through this.
Yes.
So back in April, after our first meeting on this, the request was that I just threw in every Chapter 111 stat section, so the group could go through and make sure that none of this, look at each section to see if any changes were needed. So does anybody have anything that needs to be addressed in Section 12? That's 111.015. I wouldn't think so, but okay. Section 13 is dealing with it's 111.025. Is there anything people have had an issue with that they'd like to fix in that section? No?
Section 14. I think we'd all love to get rid of the county court jurisdiction, but I don't want to take that on.
Yeah, that actually dovetails into the repeal of, which one is it? 111.055. So when we first met, we talked about potentially repealing that, and that discusses the transfer of jurisdiction and authority
Yeah.
from circuit courts to county courts and vice versa.
Right.
So I talked to Marisa James because the group last time you were
We left it in.
met, yeah, and I asked her if she could remember why the group left it in, and she said that it basically, that section doesn't create any problems, and it's possible that it was put in to remedy something that we're just not understanding right now, and she was hesitant to remove it without having a better understanding of what the purpose of the section was. And
I
so
think that was about where we ended up last time too. Sort of, it doesn't do any harm, and it might help. But yeah, so I can certainly leave it in. I mean, when was the last time anybody looked at it?
Agree. I think
agree
it's
to
just
leave.
it's a historical place marker, and let's just leave it.
It's amended in 95, it looks like.
Okay.
All right, so I'm gonna remove that from the repealed sections and just
Okay.
leave it unless people come up with a reason that they think it needs to be taken out.
So we've covered section 15. So we're changing the language probate court to over probate matters. Probate court does appear elsewhere as we go through here. Is that? What was the thinking about that? You to remember?
Brooks, I do not.
I thought we were concerned that there aren't courts that are probate courts as we have in section 14, that there are county courts and then there are other courts, and it was just probate courts seemed wrong. I had forgotten, however, that there are other places where we still use the term probate court. So
Yeah.
I thought we were taking it out altogether.
Or we could add probate court to the definitions in 05 as a court having jurisdiction over probate matters, and then just keep using probate court.
Actually, it is in there.
It is? I looked for it just now. I didn't see it.
It's under paragraph 7. Court or probate court means the court in which jurisdiction of probate matters, causes, and proceedings is vested.
Oh, okay.
As provided in ORS 111.075.
Then I think we can keep using probate court.
Yeah, I think we actually resolved that issue in the April meeting.
Okay, so let's restore probate court in section 16 then. Sorry, in, where was it? Oh, in section 15? Yeah, section 15. Or in anything, we just restore that deleted language.
Okay.
Okay. So section 16.
All right, subsection 2, I think some of this, the subsections 1 and 2, that's just cleaning up the language, I think. And then subsection 4 is new language, 4 and 5, that was proposed by the group. And apparently this is modeled after the protective proceeding statutes, talking about what a court can do. So if somebody who was involved in the thought on that proposed language has some comments.
So this is Brooks. I'm looking at 4 sub E, the part that begins subject to ORS chapter 90. We routinely run into the problem of a non-tenant child, heir, someone squatting in decedent's home. And of course, under the definition in Chapter 90, if they don't have a rental agreement, they're not a tenant. Does anybody worry that the subject to language here would imply that they suddenly get the tenant's rights because the property they're squatting in is within a probate? I'm not sure I do. I just wanted to flag that and see if that's the way it reads to anyone.
I don't think so. I think you would just look to see, you would just, this, to me, this says that you look to Chapter 90 to see what the respective rights are.
Yeah, and then in Chapter 90, you'd say, question 1, is there a rental agreement? Answer, no.
Right.
This chapter doesn't apply, go away. Okay, that's fine with me.
What does this duplicate that is in Chapter 114 already? Because in Chapter 14, we have a lot of, Lorianne, did you look at Chapter 114 in this?
What are you looking at, Lane?
Well, the litany of things that this new language, what it says that a court can do. Chapter 114 addresses things that a court can do as well.
So just to give a little bit of context here, for the most part, I did not mess with the proposed language unless I saw something significantly erroneous or an issue. And usually with those, I flagged it with a comment alongside because I wanted the group to be making those calls. So I have not looked, as far as I know, gone through Chapter 114 to see, but I could.
Does anybody else have any thoughts on that? Or the other question is, does this belong more in 114 then? It seems to me we've got similar things being addressed in two different chapters here.
Because 114.225 says a personal representative has a right to and shall take possession and control of the estate of the decedent, blah, blah, blah.
That was my question, really, to the extent how does this duplicate anything in 114, or does it belong more in 114?
I guess along those same lines, my question with it is there any question that the court can do? Has there been any question about whether the court has the authority to do these things? What is it that's trying to be resolved by the addition of the language? And if it's not an issue now, is it necessary to add the language?
Well, 114.225 is shall take possession, but that's directing that, has a right to and shall take possession. And occasionally a personal representative doesn't want to take action, and I've seen that statute used, but that's kind of not your question with regard to 111.
And 114.275 says a PR or any interested person can apply to the court for authority, approval, or instructions on any matter concerning administration, settlement, or distribution of the estate in the court without hearing or with. So that's a very broad grant of authority to courts in that statute.
So is this laundry list is something that wants to clarify it for the personal representative if they want to do it, and for example, at Devizee, if the personal representative isn't doing something? Is that the purpose of 111, this section?
Can I ask a clarifying question?
Yeah.
Lane, is your question answered by the distinction that 114 appears to be related to powers of the personal representative, and this new paragraph in section 16 applies to the court? So we have two different parties? Or are you still thinking that, you know, if 114 is granting a power to a PR, then how does the PR execute that without the court's assistance?
Yeah, and that
so
goes
it's
back
implied.
that goes back to ORS 114-275 that has tucked in it the fact that the PR can apply to the court you know, on any matter concerning the administration, settlement, or distribution of the estate, which invokes then the authority of the court. That would seem to be coextensive with the authority of the personal representative. And so all these things, yeah, so in creating this laundry list, does it somehow, I guess, yeah, what are we doing? I'm certainly sure we're not limiting the general authority the court already has.
There is, as far as legislative interpretation, there is the potential that by creating this laundry list of things and saying the court may do these, that the later court could interpret that to mean that the court can't do other things if they're not enumerated on the list, when the list is that long.
But is that true in light of 114 that gives, chapter 114 that gives the court very broad authority?
Where does 114 do that?
114-275. Second sentence. However, huh?
That's that might be, that would more appropriately be item J in the laundry list.
Oh.
In the past. That's not enough.
Well, okay. I mean, so that kind of gets back to my question then, is whether you move that into 114-275 into chapter 111, or whether you move this laundry list in 111 into 114. Somehow it seems like those provisions ought to speak to each other more clearly than they would if we just drafted this and left it in chapter 111 and left 114, for instance, 275 standing all by itself.
I don't see 114-275 as granting any authority to the court to do anything. It just, it grants authority to the personal representative. You get court approval on stuff, but it doesn't grant authority to the court. If you want to have something that gives the court authority, it needs to be the laundry list, and that would be the last item on the laundry list. You know, anything else related to the administration of the estate. And I don't know that it would fit into 114 necessarily.
Okay. Yeah, maybe better to move it into one. Yeah, maybe.
Yeah. Yeah, 114's, you know, the administration of an estate. If you're going to give the court powers, you need to have them apply to all the chapters, not just 114.
Okay.
So,
yeah.
The initiation meeting, you got will contest, you got all kinds of stuff, you know.
Yeah, John, that's not a bad idea. If we take that language from the second half of 114-275 and make that item J. What do you think of that?
Yeah. And that solves Lori Ann's question about does the specific eliminate the general?
Right.
You got it.
So how would you like that worded? Just or any other?
Yes, I would say any other.
Any other matter concerning the administration, settlement, or distribution of the estate?
Yeah.
Yeah. Yeah, words like that.
Okay.
Question about paragraph 3 in 111095. Probate court has full legal and equitable powers. This relates to our earlier discussion to make declaratory judgments as provided in ORS 28010 to 28160. If we are repealing 28040, do we need to change this in any way?
Yeah.
Because we think now maybe we just strike as provided in ORS 28010 to 28160 and leave the rest.
I don't know that you strike the rest of it. I mean,
No, leave the rest. Keep the rest.
the Declaratory Judgments Act sort of defines what is a declaratory judgment.
Right.
We're only getting rid of 28040 because, at least with respect to probate estates, 28040 is entirely subsumed by this subsection that we're looking at.
So if we do that, we can leave this in. It's just that 040 won't be part of that series that's referenced anymore in this subsection 3.
Exactly.
Yeah. But otherwise, the procedures of a DEC action would be incorporated by that. I think that makes sense.
So go ahead and leave the cross-reference to the Declaratory Judgment Act.
I think so.
Okay. Can we move on to subsection 5?
Yep.
So does anybody have an issue with this subsection? It kind of feels like this should go in chapter 114 because this is talking about what the PR does.
Yeah.
But
and we have specific statutes in 114 about compelling delivery and possession.
So 2 quick points on that. This is Brooks. I like codifying the practice that most of us already engage in, because I've been worrying about getting pushback of, and I've heard this from some self-represented litigants, where's your authority to kick me out? And I can't point to a statute. So I like this. I do agree. I think it ought to go in 114.
It should go in 114-275, probably.
Probably so.
No
or
question.
114-2225.
Lorianne, you can figure that out.
okay. All right. Does anybody have any comments on the text of it? The notice provision we can resolve after at the next meeting when we talk about notices.
So what this says is if you've got a tenant that's under a Chapter 90 tenancy, the PR won't be filing a motion for delivery under the, they'll be filing an FED.
That's exactly right.
Right. Okay.
And I like making the PR explain why 90 doesn't apply, because we, at least in my practice, we already do that. We say the person has no rental agreement in our motion papers, but forcing that to happen will save the probate court some time, where people who don't know the law come in and say, well, wait a minute, you got to give me 30 days, blah, blah, blah. This should help the court make these more streamlined.
Why do we need clear and convincing evidence that Chapter 90 doesn't apply?
Yeah, I was going to ask about that too.
No, that needs to be a preponderance. There's no reason to raise that burden. It's preponderance. It should.
So we just say the court shall find. No, let's see.
Yeah.
We presume preponderance of the evidence unless we say otherwise. I see no reason to say otherwise here.
So do we need C at all? Or shall the court, maybe it is. The court shall find that ORS Chapter 90 does not apply.
I don't think we need that, because that's a necessary part of the PR's prima facie, as we put it, setting this out. And calling out the specific finding is like saying in a negligence case, the court shall find the defendant was negligent. Well, of course, that's obvious.
So are you saying we should get rid of paragraph C altogether?
Yeah, if we're not requiring a higher level of this than preponderance, I don't know why we would need C.
Agree. Why are we
And,
making this factual finding necessary when there's lots of other factual findings that we could talk about here? I don't think we need to do any of that, John.
The occupants would raise that as a defense if it existed. They get notice, that makes them a party, and if they don't raise it as a defense.
And they absolutely do. I will never forget being beaten by a self-represented person on that topic. So, you know, that's out there.
Oh, I missed that. What was your comment, John? Are we leaving it in or taking it out?
Take it out, because if there's a Chapter 90 issue, the occupant will raise it as a defense.
Yeah, right. Yeah, okay, good point.
Right.
Okay.
So I think that takes care of section 16, unless anybody has any other comments.
No.
All right, so section 17. This is another one of those kind of a little bit antiquated sections. It's talking about the appeal of cases decided in probate courts. And this is entirely language that was proposed by the group to be inserted into this section, and I'm wondering why, if it's necessary. Primarily because we've already talked about these county courts as being probate courts, so is there a reason that we need to call them out specifically again?
Well, you're not calling them out, you're sort of limiting this section to them.
Yeah, is that necessary?
Beats me. Whose idea is it?
Not mine.
Not me.
Not me.
I think it was, I think that this came from Jennifer and who was the other person that was working on the original
Heather?
language? Heather
Heather?
and Jennifer. So
Yeah,
maybe
Heather and
before
Jennifer.
we take it out, just hold on this one and come back to it next time when they're here and can explain the thought process behind it.
Well, I'm just, yeah, it's curious because then what we're saying is that, well, no, okay. Huh.
So is there a question about when the county courts decide something? Is that the reason they put it in? Is there a question about whether it goes up to the Court of Appeals or whether it goes to the circuit court?
Yeah, if you look at, let's look at this. In sub 3 says appeals from county courts go to the circuit court first. So if you go back to 1, it says your appeal goes to your circuit court if you're in one of those counties. But with this, but what this is making, I guess, is if you're in one of those counties, the circuit court isn't going to retry the proceeding. But I think it already says that.
Well, but in 3, it says appeals from a county court shall be taken. So is that treated like if you take something from the circuit court to the Court of Appeals, that the facts have already been established, as opposed to you get to try the whole thing over again in those counties? Is that what 1 is trying to say, that you start all over again? It's de novo in those counties if you take it to the trial court?
Okay, maybe that's it, because our county courts of record, and they may not be, and so if you're taking something from Gillum County Court to the circuit court, there may not be a record, and it may be necessary for the circuit court to rehear in order to create a record.
Because I'm wondering if it shall be tried again is the pertinent language in 1, and then 2 and 3 basically, direct a probate court goes to the Court of Appeals, a county court goes to the circuit court.
Yeah.
I'm guessing.
I think this language doesn't make any difference. Says, if you look at 1, no issue determined in a probate court shall be tried again on appeal other than those appropriate issues determined by a court of record. Well, all of our trial courts are courts of record. So this says that, a determination made by a trial court, a circuit court, is not going to be retried by the Court of Appeals because it's a court of record. In Gillum Grant, in other probate courts, which includes the county courts, whether we say so or not, the question is going to be, is there a record? And if there is a record, it's not going to be tried again. And if there's not a record, it will be tried again in order to create I think that's the way it works, even without naming those counties.
What is the effect in paragraph 3 to the reference to ORS 5.120? I'm looking at that, and 5.120, paragraph 1, the last sentence describes that the appeal shall be prosecuted, heard, and determined in the manner prescribed by law for the prosecution, hearing, and determination of appeals from the justice court. Right. So it might be importing some procedure there.
I just think the language that we've added here doesn't change the statute. Because the extent the statute would apply, it applies to those courts that if they're not courts of record.
So can we kind of stylistically change this a little bit? In 1, change it to a county court exercising probate jurisdiction.
Which harmonizes it with 3, yeah.
Yeah, and do the same thing in 3. So
yeah.
Basically taking the style out of 2, which makes sense, and saying, because, maybe Grant County might get a probate court someday.
Right.
And so in subsection 3, change it to appeals from a county court exercising probate jurisdiction shall be taken.
Yeah.
Yeah.
And do the same thing in 1. No issue determined in a county court exercising probate jurisdiction. That makes sense. I'm still not sure it changes anything, but
I don't think it does. It kind of clarifies it, but if you fix that, it's stylistically better, and then everything else is existing. So none of us have any reason to change it.
Yeah.
Do county courts exercising probate jurisdiction, do you have to be a judge or an attorney or pro tem or something like that?
Nope. You have to be the elected county judge.
I have one out in, I think it's Malheur County right now. I'd have to look. And it's involving a couple of $1 million, and our judge is a heavy equipment operator.
I love it.
All right.
So we've got about 6 minutes left.
Yep.
I think I will go ahead and make these are pretty simple changes. And I'll put together that list of the use of the term interested person that's relevant to what we're working on, and then have Sandy recirculate that.
Yep.
And my understanding our next meeting is going to be in...
Yeah, we're on the 29th.
And then you had sent around another copy of the e-wills, right?
I did, yeah.
I hope that we might get to it today.
Yeah. During this meeting, I did send everyone a copy of the full e-wills Uniform Act, as well as Lorianne had done some work back in April, and we were planning on discussing it.
Yep.
And I sent both those documents out during this meeting.
So here's what we'll do. To keep this moving on both fronts, we will spend half the time next time on Chapter 111 revised, And then we will just stop at that point and shift to e-wills to get some conversation going there. I think it'll be good for our heads too, to be talking about something other than chapter 111, just for the sake of the change of subject matter.
And what I'll do is I'll send, as Lorianne sends me updated documents, I'll definitely send a reminder a week ahead of that meeting as well.
Sure.
And I'll include the e-wills documents in that email as well, just so everyone has it on hand.
Yep. So we will get to e-wills next time. I don't expect we'll finish 111, but we're making enough progress now that I'm feeling better about it. And Lorianne will just leave the representation business behind.
Yeah, and another thing is I'm going to work on trying to condense down all of the notice provisions into one section.
Good.
So I'll do that as a track changes so you can see what's happened there.
Good. All right. I think we captured some ground this week. That feels good. Anything else for the good of the order before we finish? Otherwise, like I say, next time we will spend half the time on 111 and then we will just cut it off. Knowing that we won't be done, but we'll reserve time in meetings going forward. But I want to get to a serious shot at e-wills before we run out of time.
Okay.
All right.
All right.
Thanks, Lorianne. Thanks, everybody.
Thanks, Lorianne. Thanks, Lane.